Hey, what's up, everybody? This is Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about the CFPB sues Portfolio Recovery Associates $24 million settlement. But I'm going to tell you exactly what is not being said. I'm going to also talk about some of the misconceptions about, number one, why debt collectors are willing to do this and get sued and be happy to lose. I'm going to point out to you why they are happy to go through this. That might sound crazy, but they want this to happen because now, when it's all said and done, they get to run off with all of the money. The next thing is that there's a lot of mass confusion about people getting sued, about where you're at in the let's just say, how do I say this? Where you're at in the pipeline of a debt collector dealing with the debt that they purchased from you. I get a lot of calls, get a lot of emails, live chats. People are like saying, I'm getting sued by a debt collector. And I'm like, who are you getting sued by? I don't know who I'm getting sued by. They just tried to serve me. Okay, you got to find out who is trying to serve you. Call the courthouse, get the document, because they're not going to stop just because they didn't get you. Some, you might get lucky and one time they might stop, but most of the time they're going to continue coming after you. So you got to find out where you're at in the pipeline of them suing you. Some people say, well, I know that I got a call from a debt collector. Okay, if you got a call from a debt collector and they're threatening to sue, that doesn't mean that they've already tried to sue you or that they're putting the paperwork together to sue you. It's just that they're trying to collect the money. They're trying to get the information from you. And they might say, well, hey, if you don't pay, we're going to sue you. You're not in the suit process if you're dealing with that. You're in the debt validation process. That's when it would be optimal time to do a debt validation to them, telling them to send everything that they got about it. They're going to probably send you a statement. And then if they send you a statement and they don't send you the correct letter, giving you the opportunity to dispute the debt in that letter. You can do this on your own. You always have a right to dispute the debt. But here's the thing about it. When a debt collector sends you the initial letter, the initial demand letter for you to pay that debt, it has to have a few things on there. Number one, it has to say who the original creditor was, who they purchased the debt from, who they are. They have to identify clearly who they are, and they have to have a section that allows you to, number one, know that this is attempted to collect the debt and that you can dispute any or all of the debt, that you have that right to do that. And it is not a bill, even though it will look like a bill. It's really a letter that allows you to dispute. That's just like putting everything on record saying, hey, we're trying to come after you. If you don't respond to that letter, they're going to be able to put that information on your credit report. That's where you're at in their pipeline. And then some of the other things that I want to make clear to people, looking at my notes here. So say you are doing a debt validation. You're doing a debt validation to Original Creditor Collector Bureau. Some people seem to have that all reversed the other way. They're doing the Bureau, thinking that the Bureau is going to do a debt validation to the furnisher. Some of the times it could happen. Most of the time they're just going to send you something back saying that it was verified. That's what they're going to do. We all see that a lot of the time. So what you want to do is you want to go directly to the furnisher or the original creditor. If the original creditor sold the debt to a debt collector, you would send information to the original creditor saying that this debt is paid. You want to have it marked as paid on there because you've accepted money from someone else. It doesn't matter. It's like you're accepting a settlement, even though it's pennies on a dollar. You've just accepted a settlement. So either put it positive or remove it off my credit report. They usually just remove it. When you're dealing with the debt collector, and this is before a lawsuit, you're going to do a full debt validation. And what I give you later, I'm going to give you a letter that's called a cease and desist collection activities letter, not cease and desist communication. You want to keep the communications open, but you want to have them, put them on notice that you want them to do everything to prove that you have to pay them that debt and the amount that they're claiming on that debt. And then you use that documentation that they gave you to go to resubmit that to the bureaus. We do that all the time. We'll get documentation from the original creditor or the furnisher. They're saying that they're going to remove it, that they're not gonna go after the individual with the collection, that they're going to remove it. We'll use that documentation, send that to the bureaus, get that information taken off. Now, if you're being sued by a debt collector, this is the process that you're in. This is where you're at in the process, is that you have to respond to that court summons, and that court summons is going to also be responding to the debt collector. Now, if you're being sued by the original creditor, then that court summons response will be sent to the original creditor. Some of the times I see the comments and people have that kind of confused. What they'll do is they'll get sued by a debt collector, and they won't respond to the court. They respond to the debt collector. You have to respond to the court. You could be making a huge mistake by responding only to the debt collector. Debt collector says, well, they just disregarded what the court asked them to do. So you got to be very careful. You got to respond to the court and then let them tell you how they want you to get it to the debt collector. Same, even if you're dealing with an original creditor. See, when they bring the court into it, you actually have to respond to both parties, because the court is like this: hey, we're over both of y'all, so you brought us into it, so you need to give us information so we can put stuff on our schedule and know what we need to do to clear this civil matter up. That's basically where they're at, but they don't want to be disregarded. Like, they don't want you just to be like, okay, well, we're going to talk it out without letting the court know. You can talk it out with them, but the court always is going to want to know what we got to do if it was a resolution or whatever. And you have to send documentation, either the debt collector or you're going to have to send it saying that it was resolved. And whoever brought the action is going to have to send documentation saying that it's resolved if it gets resolved. And then the debt demand letter, which I just spoke on that a minute ago, is that you have to respond to that debt collector, or even if it's from an original creditor and you have some sort of dispute with them, you have to respond to them. So what I don't want you to do, what I want you to pay attention to, is that find out where you're at with your process. Are you being sued, or are they just calling you, or are they sending you letters? Where you're at with that is where you start to go. Don't stack on top of their things that they haven't done yet. Like a lot of people will say, they'll be like, I got a letter, they're threatening to sue me, and they think that they're already getting sued. Or they got a call and they said that we're going to sue you, and they think that they're already being sued. And so they forget to do the process that would be of most value for them to stop the debt collector, because they're thinking about responding to something that the debt collector hasn't done. And the debt collector is not required to respond to something that they haven't done yet. They just put that impression in your mind, and that makes you think, okay, they're suing me, when you're supposed to be responding to the Dunning letter, to the 30-day letter. You forget to respond to the 30-day letter. Now they put it on your report. Now they have more evidence to be able to go to court because you didn't respond at the appropriate time to the appropriate thing. That's all I'm trying to get across to you. So now let's get into it here. This here is going to validate a lot of stuff that I've done. Stay on this video. This is going to validate a lot of stuff that I've been telling y'all. Let's just get to it. All right, so CFP orders repeat offender. So let's go ahead and just mark up some stuff here. CFPB orders repeat offender portfolio recovery associates to pay more than $24 million for continued illegal debt collection practices and consumer reporting violations. So they're putting negative information on individuals' credit reports that they shouldn't be able to put. They're still doing illegal debt collection practices. I'm going to point out exactly what they're doing, and you don't have to take my word for it because CFPB is explaining that. But let me break down first, because I made this promise. I said, why Are they willing to do this? And as a matter of fact, this here makes them smile. This makes them smile. I'm going to show you something real quick. This here makes them smile. So let's look right here. As a matter of fact, they were sued back in 2015. Okay, so here we go, right here. Let's see if we can, I don't know if I can't blow that up, but right here, this is it. I'm gonna write this out for you right here. So in 2021, they reported a net income, look at this, 183. You put the rest of the zeros after there. $183 million. If you came to me, or I came to you, we came to someone else, we go to Portfolio, we go to anyone on the street, and we say, okay, you made $183 million, and I'm going to fine you 24 million of that. So that leaves you, we put that 7 there, and we have our 9. So you lose $24 million and you keep $159 million. And as it states in here, only $12 million of this amount of the 24 million is actually going to be cash. Is actually going to be money that they actually have to put into a fund. So, and something else that's crazy, $24 million. If you bought the debt for 1 cent, but you're claiming that the debt is like $5,000, are you really losing the other $12 million? Are you really losing the other $12 million? So really, if you really look at it, the money that they're losing, that they're actually having to put into it, is actually only $12 million. It's actually only $12 million is what they're putting into there. And so that means that they're going to keep $171 million from that year. Wouldn't you do that all the time? It's like this is the cost of business. This is like our advertising. We're spending $12 million a year on advertising. That's what they're doing right there. So here, let's get to it. Let's just y'all maybe don't care about that. I don't know. You may not care about that. So here we go. Here, debt collection giant files lawsuit, even though when they lack the documentation about the debt. We always talk about it. I say that it is not. It's not about going into court and just saying deny. Deny is going to get you a judgment. What it's about is making them prove with documentation that you owe that amount. The whole, like if there's a bottom line, some people will be like, well, Steve, tell me the bottom line. What's the bottom line? Bottom line is, how did you come to that amount that I owe you? Well, we have this document, a statement. We got 2 statements. That shows how we got to that amount. Okay, well, that's not a full accounting. If you were the original creditor, I would be able to get a full accounting. Well, are you disputing any part of the debt? Well, that was something that was going on between me and the other party. And when you assume the responsibilities of taking on the debt, you would have all of those documents that prove if there were disputes, if there were not disputes, anything. I don't have to actually tell you, you need to give me what I'm asking for. And this is what they don't want people to know about. This is what they don't want people to say. This is what they don't want people to do. Debt collectors don't want you to know this, because this is the bottom line of every court action. They'll say, you should have had disputed it. Do you have disputes? They'll say the Supreme Court said all we got to do is have a couple of statements, the chain of custody, all of that stuff. Yes, but also it states it even right there, documentation about the debt. So let's read here. The Consumer Financial Protection Bureau took action today against Portfolio Recovery Associates, one of the largest debt collectors in the nation, violating a 2015 CFPB order. So they're violating an order that they already had. CFPB proposed order today, if entered by the court, would require Portfolio Recovery to pay more than $12 million to consumers harmed by illegal debt collections practices. In addition, $12 million penalty that would be deposited into CFPB. So I guess it is 24. So I take that back. I read it wrong the first time. It is 24 million that they would have to pay, and they would also put 12 million deposited into a victim's relief fund. Portfolio Recovery Associates violated the 2015 order by collecting unsubstantiated debt, collecting on debt without providing required documentation disclosure to consumers, suing or threatening legal action against the consumer without offering or posing required documents, and suing to collect on debt outside the statute of limitations. You see it right there? You see that right there? Who was that person that said that no debt collector tries to sue anyone past statute of limitations? Here we go, right here. Past statute of limitations. Portfolio Recovery Associates failed to properly investigate and resolve consumer disputes about the company's credit reporting. Look at that right there. People disputed the information on the credit reports. They did not resolve that. Now, you might be saying, well, why didn't the bureaus resolve it? Well, we already done talked about that in other videos. Portfolio is the bureau's customer. They're going to allegedly, my opinion, do what Portfolio tells them to do. And if Portfolio does nothing, that is like telling someone what you want done. And what do you want done? I want nothing done. So even if Portfolio does not respond to the bureaus have not been doing their job on removing that information if they didn't respond. Now, you might be saying, well, that's against the rules. That's against a violation of the Fair Credit Reporting Act. They're supposed to do that. You saw my video. Type in, after you watch this video, type in Representative Clyburn report. And you'll see a video where I showed Representative Clyburn, United States House of Representatives, Clyburn had a report where it showed that the bureaus were throwing away millions of disputes. And before you start saying, well, there's nothing you can do about it. Yes, there is something that you can do about it. You continue fighting. This is not about quitting. This is about continuing to fight. I'm just letting you know what it is that you're fighting against. When you know what you're fighting against, it can help you keep fighting. So today's action is one of many actions CFPB has ordered taken to hold repeat offenders accountable. After getting caught red-handed in 2015, Portfolio Recovery Associates continue violating the law through intimidation, deceptive, and illegal debt collection tactics and lawsuits, said CFPB Director Chopra. CFPB orders are not suggestions, and companies cannot ignore them because they're large or dominate the market. So let me pull this down here. Portfolio Recovery Associates, wholly owned subsidiary, traded PRA Group, NASDAQ PRAA, which is one of the largest debt collectors in the United States. Net income 2021, $183 million. 2015, CFPB ordered Portfolio Recovery Associates to pay $27 million in consumer refunds and penalties for deceptive debt collection tactics. In that case, CFPB found that Portfolio Recovery Associates collected on unsubstantiated debt, filing misleading affidavits in debt collection actions, misrepresented that it intended to prove debts if the consumer contested them, and misrepresented that the company had legally enforceable claims. This is a key word right here. This is the key word that I talk about right here, claims. Outside of the applicable statute of limitations. So Looking at this here, this is the 2015. The 2015 order required portfolio recovery associates to adhere to provisions including get my words mixed up, prohibitions on collecting debt without reasonable basis, selling debt, which we know that I'm not sure which one this. I don't want to misspeak, but there's a company that's above, that's under portfolio recovery. Sometimes portfolio goes after, but there's another company that's below portfolio recovery. That was one of the reasons why they were able to get away with stuff. Threatening or filing collection lawsuits without an intention to prove the debt. And this is something that we just spoke on. Filing false or misleading affidavits in debt collection actions. I've talked about that before, where the affidavit that they would put together, it is not from the original creditor. They're trying to give the impression to the court that affidavit was produced by the original creditor. It was not produced by the original creditor. The debt collection company knows that it wasn't produced by the original creditor, but they're trying to give that impression. And I've talked about that a lot of times, where you got to read your documents. You got to look at those documents, and when you look at them, you can say, this is not some, they're trying to make this look like it's from the original creditor, but it is not. And they do that with various documents that are inside of the summons, where if you look at them and you're like reading them and you're like, man, this is pretty good evidence that they're putting in with these documents, and then you review it and you're like, if it was from the original creditor, but it's not. This is someone that is usually some assistant or a representative of the company, and they'll say, like, we're familiar with the way that the business practices of the company. You can't be familiar. You don't work for them. So this is something that they've done, and I've talked about this. Making false, misleading representations and collecting or suing debt that was outside the legal statute of limitations. There you go, right there. This is directly from the CFPB right here. This is what they were doing from the 2015. This is what they got in trouble for in 2015. So let's continue. So when they talk about making representation about unsubstantiated debt, portfolio recovery substitute made tens of thousands of misrepresentations about unsubstantiated disputed debts, failing to review the required documentation to support the claim. So everyone that's upset that when you're trying to work on your credit and you don't get the response that you want, and you think that everybody has to follow the 30 or 45 day, this is the law, this is the demand on the law and all of that stuff. Well, look at this right here. This is what you're going through. This is what we go through. That's why you gotta be ready to fight. It is not gonna be an easy battle. Get that out of your mind. It's not going to be an easy battle. Start thinking positive and get ready to work, because these companies are in the business of making money, and they're going to do everything possible to try not to do their job. Next thing is threatening consumers with potential legal actions and initiating debt collection lawsuits without offering or posing required documentation. Portfolio recovery associate, debt collection attorneys, lawyers sent millions of form letters to consumers notifying them of potential legal action without offering to provide all the required documentation. Portfolio recovery associates initiated thousands of legal actions against consumers. It lacked proper documentation. So you send out the debt validation, you send out the debt verification, they don't respond back. You are stuck with talking about, well, you have to respond back within this specific period of time, and because they don't, you get frustrated, you quit. That's what they want you to do so they can continue with the action. You see it right here. Everything that you're going through when you're having a hard time to repair your credit, this and doing debt validations and wondering what's going on, this is what's going on. So you have your answers right there. Next one. Misrepresenting that it would provide certain documents within 30 days The form letter notifying consumers of potential legal action stated that upon receipt of a written request from the consumer, Portfolio Recovery Associates will provide a 30 days of requested the proof of documentation mentioned in the letter. On numerous occasions, Portfolio Recovery Associates failed to timely provide the documents after receiving the consumer's written request. Right there. Let me just focus right there. On numerous occasions, Portfolio Recovery Associates failed to timely provide these documents after receiving a consumer's written request for them. This impeded consumers' ability to determine whether a debt was truly owed or how they should respond to the allegations of outstanding debt. There you go, right there. Now the next one here, collecting on time-barred debt without making required disclosures. On numerous occasions, Portfolio Recovery Associates did not provide the required disclosures to consumers when collecting on a debt beyond the statute of limitations. When the company purchases a debt, it estimates the statute of limitations that governs the debt. And in some cases, that date was later than the actual statute of limitations. So they're not even giving. This here is where people just don't look up stuff. I've always said this, now I say it at the end of all of my videos. For any debt that you have, and that's why it's important for you to have a paid monitoring service, because the free services don't tell you this. It's like it's a setup. Like we give you stuff for free. People give you stuff for free because they don't intend for you to have all of the information. So get paid monitoring services because it can avoid this stuff right here. And I'm going to give you a letter later to help you with this, but get a paid monitoring service. I'm going to make one available to you after this, but whoever you go to it. But on that monitoring service, it'll tell you when the original creditor charged off the debt. When the original creditor charged off the debt, the original, not the debt collector. We're talking about the original creditor. That's when the statute clock starts to tick. That's when it starts to tick. So if you live in a state that has a 3-year statute of limitations on a credit card debt or a regular debt, whatever it is, regardless if the original creditor or debt collector tries to sue you, if it is past the 3-year statute of limitations, you don't have to pay that debt legally. They cannot legally come after you. They can try to get you to collect. They cannot report that on your credit reports because that would be taking an action that they're not allowed to do. So that's why it's important to get those paid credit monitoring because it's going to give you the information, the data that you need. So they're trying to sue people for time-barred debt, and a lot of people don't even know this. If they're trying to collect on a debt that is past the legal statute of limitations, they have to actually notify you the required disclosure. What's the required disclosure? They have to tell you that this is a time-barred debt. They'll use that wording right there. Time-barred. Time-barred, look it up. That means that it's past legal statute of limitations. Suing to collect time-barred debt. The next one on here. Portfolio Recovery Associates initiated at least dozens of lawsuits. It's probably more than that. It says at least dozens. Lawsuits for debt that was too old or to legally enforce. In doing so, Portfolio Recovery Associates falsely misrepresented that those consumers had legally enforceable obligations to pay those debts when in fact they did not, because the debt was outside the statute of limitations. So let's continue here. CFPB also alleges that Portfolio Recovery Associates committed numerous violations in the Fair Credit Reporting Act and implementing Regulation B, which includes failing to inform consumers about investigation outcomes. There we go here. You make a dispute to Portfolio Recovery, make your dispute to the credit reporting agencies. Seem like they're leaving the credit reporting agencies out of here because most people dispute with the credit reporting agency and telling the credit reporting agency to dispute with Portfolio Recovery. Portfolio Recovery has 30, 45 days to respond. They don't respond. Bureau doesn't do anything, because remember what I said earlier, if they don't respond, they're the Bureau's customer, and that is responding. That is saying to them, hey, that means don't do nothing. Don't do nothing. Like, nothing is something. I want you to get that in your head. I want you to say it. Say it after me. Nothing is something. A lot of people think that doing nothing is nothing, when doing nothing is something. So you dispute to the Bureau. Bureau sends that information over to the furnisher, which is, in this case, Portfolio Recovery Associates. Portfolio Recovery Associates does nothing. Nothing gets sent back. Nothing means something to the Bureau. That means we want you to do nothing, because that nothing that they do means a whole bunch of something to you. So nothing means something. And we had a proof right here: failing to inform consumers about investigation outcomes. On numerous occasions, when Portfolio Recovery Associates determined that the consumer's dispute was frivolous, they say that it was frivolous or irrelevant. They say it was frivolous or irrelevant. It failed to timely inform the consumer about the information that would be necessary for Portfolio Recovery Associates to investigate the dispute. Let me talk about this one right here. The reason why they would say that it's frivolous is because people say that they deny owing them the debt. They never put them to the task of saying, I want you to prove every amount in there. Show me all the charges. Show me all of the PIN codes. Show me all the signatures. Show me enough to prove that claim. Here, you're claiming $10,000. Portfolio Recovery, they send, maybe they have a contract. Let's just give it to them. Maybe they have the original creditor contract. They have 2 statements. They have an affidavit from the original creditor. Maybe they got some other stuff. But the big elephant in the room is this right here. How do you get to this amount? So what you want to do, forget about this denial game. I deny this, I deny that. Let's not get into that game. Let's get into this game. Show me, okay, we got $10,000. Let's show me the charges, because on this statement that you sent, these 2 statements, this one might show 9,000. This one might have a balance with 10,000. So you can prove that I did $1,000. Okay. So we got that proof. So we minus. So now we got $9,000. I'm not running from you. I'm working with you, Portfolio. I'm working with you. So right now, okay, you sent me those statements. Okay, but now you did not give me the PIN code. But let's just say, well, I'm just gonna go ahead and say I owe that $1,000. I'm gonna be nice to you. You showed that. You gave the 2 statements. But what about this other 9,000? What about that other 9,000? See, over here, you didn't respond because you did not have all of the documentation. We have that here. CFPB also stated that. So now, are you trying to say that it was frivolous or irrelevant because I'm asking for this? No, that's not, trust me, when we make these requests, it's not frivolous or irrelevant, because there's a lot of information in there that we ask for. Frivolous and irrelevant claims, that's all about people that just deny. And I remember what I told you, what deny means. That means that you get a judgment. Deny and judgment. So deny equals judgment, because you don't deny. You're asking for more information. When you back them into a corner about that, trust me, I see this all the time. They forget about you and they go on to the other people that don't know this stuff. Failing to timely resolve disputes on at least tens of thousands on occasion, Portfolio Recovery failed to resolve disputes within the required period of time. So, upset about that 30 to 45 day period. Look, this is what they were doing for years, right here. For doing it for years. So what I told you, it's a fight. You got to continue fighting. Next one, conducting unreasonable investigation. On numerous occasions when a consumer alleged fraud or identity theft, portfolio recovery did not conduct sufficient investigation. Efficient investigation. It's crazy. All right, let's move on. So this is what they're going to do under their action. So this is the settlement agreement. Provide redress to consumers. Portfolio recovery associates will pay at least $12.18 million to consumers harmed by illegal collections. When I find out the website that you'll be able to get, if you're a part of this, the victim. Well, they have a. We'll click that in a second. Well, that's the Victims Relief Fund. They're gonna, I guess they're gonna they usually have an administrator website that'll handle that. Clean up its faulty operation in order to prohibit portfolio recovery associates from collecting on debt unless it has access to certain documents that meet its obligation. It says here, meets its obligation to have reasonable basis to believe it is collecting debt that consumers actually owe. See, I don't like that. I don't like that. I don't like that. I do not like that. So it says here to clean up their faulty operations, prohibit portfolio recovery associates from collecting debt unless it actually has access to certain documents that meets its obligation to have reasonable basis to believe it is collecting debt that consumers actually owe. So here go the key words that I look at. And then access. Right there, those two are very important. So this goes back to what I talk about all the time, which is we need to make them prove every dollar, every penny that they're claiming that an individual owes. I don't want the CFPB to have the debt collector kind of have an escape hatch to be able to get out of something that they originally intended them to do. Because we don't want portfolio recovery to determine these things. We want it to be determined based off of the documents that are requested to prove the claimed amount. We don't want them to say, well, we had a reasonable, we got documents and we got the two statements and we got all. Really, that it doesn't change anything unless you make that request and then they feel that request is something that they have to get. And then if you go to court and if the judge sees it your way where you're like, hey, not running from this. Your Honor, I'm not running from this. What I want to do is let's just add up all of this on those two statements. It just doesn't add up to be that. I want to look at all of those documents. I hope that this doesn't give them like a little window that they can crawl out of. Fix its failure to properly respond to consumers. Hopefully they can get that fixed and then pay a $12 million in penalties into the victims fund there. I don't know how that's going to be distributed. And then they had some other stuff. So this was done not too long ago. This was done last month. It kind of went under the radar. So if you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, What Makes Us Different, so you can see my 8-point validation process, my two-phase settlement process. If you need your credit reports and scores, and this is very important, where you would know if your debt is time barred, you will know if the information on that the debt collector placed on there is not properly done. And if a debt was sold to the original creditor, you would know exactly what address and what information you will need to respond to the original creditor to make that dispute, stating that they have taken a payment for that debt. So they need to either put it positive, paid for less, they could do that, or just take it all the way off the credit reports. That's what they would need to do. So go to the number 3scores.com. The number 3scores.com. Link is below this video. If you have debt collectors coming after you, I want you to grab my 3-pack of letters. statute of limitations letter for debt that is past the legal statute of limitations to collect. A lot of this stuff could have been stopped if people had my letter, the statute of limitations letter. No debt validation is required. Remember what I said earlier, know where you're at in the process. If your debt is past legal statute of limitations, you have no reason to do a debt validation. As a matter of fact, this is probably why Portfolio continued, because they were like, these people don't even know that we can't even collect this debt, so why even worry about it? They're not going to be able to afford an attorney to go after us, so just do it, allegedly, my opinion. So, but we see the end result, so something was going on. So, get the statute of limitations letter. All you have to do is notify them. I tell you exactly what to say. In the letter, the link is below here. I do ask for a donation because it can save you time, money, frustration. And also included in that pack, if your debt is not past legal statute of limitations to collect, I give you a cease and desist collection activities letter. This letter is so important, and it's not a cease and desist communications letter. It's a cease and desist collection activities letter. The reason why this letter is so important is because, remember, they were saying, and the CFPB was saying that they didn't have the documentation to prove that the individual had to pay the debt. Well, that's what I did in this letter that I crafted. I crafted this letter from what I've seen with thousands of customers, with different cases that were out there, with just bottom line, what debt collectors are required to do. But it had to, I crafted this letter in a way that will get their attention. That's what's so different. It's not a template that someone had from over there, that was just floating on the internet. It is actually something that was crafted by me that has gotten a lot of attention when debt collectors receive that letter. They will usually stop coming after an individual. And then I give you a debt validation letter to go back and forth, because just like we just showed here in the video, sometimes they don't stop. I mean, they're in the business of making money, and you got to be ready to fight, and you're going to have to have that back and forth game. I want to thank you for your time. I want you to subscribe to my video. I want you to like this video. I want you to subscribe to my channel if you haven't done that yet. I want you to share this video. I want you to place your comments. I want you to review my other videos. I want you to take action, because now is the time for you to make a change in your life, to be able to start moving forward, repair your credit, get out of debt, so you can live the life that you deserve to live. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.